have any bill introductions today? I've got one bill introduction, and the RS number is 0547. That's 0547, and this is the Kansas Targeted Employment Act. Some of you are familiar with this from last year. We passed it out really late last year, and it died on the calendar because of COVID. So, got COVID and died. We have sent out new instructions for conferees. They were emailed to you prior to this meeting, along with the bill information from today. But it's an attempt to kind of organize how things are coming in and how we can get them to you in a more organized manner for, for presentations and for hearing of bills. So hopefully we can get a little more organization here. With that, we'll go ahead and open discussion and action on HB 2112, and we'll start with a briefing from Reviser Charles Reimer. Are you there?
Thank you, Chairman. House Bill 2112 makes some changes to the Self-Storage Act regarding self-storage rental units. One of the items changed in that act is that there is a limit placed on the value of personal property. It's limited by the maximum value that is stated under the terms of the rental agreement that may be stored in the leased space. There's an addition that on the rental agreement, there should be space for an occupant to designate an alternative contact if they wish to do so. Probably one of the main items of the bill, or the main item, is that it allows for online advertising and also an online sale. That's found on the bottom of page 2. There's a restriction. The advertising has to be done either in a newspaper of general circulation or in any other commercially reasonable manner. There's a restriction on commercially reasonable in the sense that if you don't have 3 independent bidders, then the sale is to be canceled, rescheduled, and re-advertised. 3 independent bidders are to attend the sale or view the sale online at the time and place advertised. Notice to the occupant of a rescheduled sale is not required, and that is what the bill does.
Any questions for the reviser? Seeing none. Okay, thank you very much. For discussion on HB 2112, Representative Long.
Thank you, Mr. Chairman. I move the committee recommend HB 2112 favorable for passage.
Seconded by Representative Sutton. Discussion. Representative Probst.
Thank you. I'd like to offer an amendment to this bill. If it hasn't been distributed yet, but I think you can go ahead with that, with number 1, Chuck.
Okay.
And then Chuck, Charles, if you could put it up on the screen, that might be beneficial.
Chairman, I will do so, and I have sent number 1 to Cindy for distribution.
Okay, and Representative, did you want to explain the amendment or have Charles do it for you?
Charles could do it.
Okay. You're up, Charles.
All right, so the amendment, if you can see my screen, on lines 36 and 38 of page 2, this amendment strikes the language "or in any other commercially reasonable manner." The period stays, so it's period after held. And then it also strikes the language on line 38 with a comma if notice is placed in the newspaper. That is what the amendment does.
Any questions for the reviser? Representative Probst. What's the intent of the amendment?
Thank you, Mr. Chair. The intent is just to maintain what we do now, which is have these published in a newspaper in the area. Everything that I've gathered is it's not onerous in the cost. It's a reasonable way. It's a place where people go commonly to look for notices like this. So I just want to clear that up and stay with what we currently do and have done for quite some time.
On the amendment, Representative Williams.
Thank you, Mr. Chair. And unfortunately, I'm going to oppose this amendment. And the reason is that we have a culture in which we are no longer accessing or utilizing the newspaper in the traditional ways. If it's provided digitally on the newspaper's website, that's one thing. But I don't want to prohibit the email notifications or the reasonable ways in which people are notified. And I think by having this clause in there or in any other commercially reasonable manner makes this a more current, more modernized approach. And so I would like to leave that as is. It's just my opinion. Thank you, Mr. Chair.
Any further discussion on the amendment? By the way, for the record, Representative Clayton has seconded the motion. I would tend to agree with Representative Williams. I think the purpose of this bill was exactly that, was to get away from having to advertise in newspapers. I'm sure that if the newspapers were competitively priced, that they would continue to use them, or I'm also sure that a lot of newspapers have online capabilities now. And so, you know, those are just kind of my thoughts. The whole intent of this bill was to get away from having to advertise in one way when they're already doing others. Representative Highland.
Thank you, Mr. Chairman. In the rural areas, it's hard pressed to find a newspaper nowadays. So it's easier to go online, and I think for that reason, I will be opposing this amendment.
Any further discussion? Representative, you may close.
I move my amendment.
The committee, you've heard the motion. All in favor, say aye.
Aye.
All against, say no. Noes appear to have it. Noes do have it, but we're back on the bill. The motion fails. Representative Probst, you have another amendment?
I do. Okay, I didn't expect that would get me much success, but I do have another amendment that hopefully you all either have or will have shortly. I have some concerns in this bill, as I did last year, that we haven't adequately defined commercially reasonable manner. And to kind of illustrate that, can I ask the reviser a few questions?
Go ahead.
Charles, in this bill, do we have, is there anything that governs what commercially reasonable is?
Representative, the only language in the bill that would go to commercial reasonably, other than, you know, how a court would interpret that, you know, this language that is, you know, may have an interpretation in opinions, would be the restriction that if 3 independent bidders do not participate in the sale, then the sale has to be reheld. But there is no other definition of commercially reasonable in the bill.
Thank you. On the line that says there has to be 3 independent bidders, is there any qualifier on who has to track that or report it? How do we know if 3 bidders do or don't show up?
Representative, there's no specific language in the bill that addresses that issue. So it would presumably be up to the owner, the individual, the business owner who is making the sale, it would be, I mean, it would be reasonable to say that the language of, would apply to that person. And so it would be up to them to do that, but there isn't anything specific.
Okay, thank you. So committee, my reason for offering this is I just feel that we've created this term, commercially reasonable manner, and we use that language. I've pulled up a couple of other statutes that apply in different areas, and those areas in other parts of Kansas law have at least some definition of what that means to be commercially reasonable. It's my opinion that if I decide something's commercially reasonable, that's commercially reasonable and there's no real definition. The definition I've provided here doesn't preclude online publication. It allows any kind of publication that just tries to create some structure. And I will welcome any thoughts on this because I don't feel like I have the de facto definition of what commercially reasonable is. So I would appreciate committee input on this. But I do feel that we need to more adequately define what that is.
Do we have a copy of the amendment?
Go ahead and, did we distribute that amendment, Charles?
I'm sorry, does the committee see that amendment?
Yeah, I do.
Okay, very good. So you'll see that on the bottom of page 2 of this amendment, there's additional text added to the end of paragraph 3 that reads, for purposes of this paragraph, commercially reasonable manner means a manner of advertising that is in the jurisdiction where the sale is to be held, widely circulated, published or available online on a consistent and regular basis, and is a known source of widely shared community information.
Is that the only part of the amendment?
That's correct, Chairman. That's all the amendment does.
I still don't have a copy of it. I certainly can't see the screen. Did you send that to Cindy?
Yes, I just did. So it should be on its way.
Representative Miller has seconded the amendment. For discussion, Representative Highland.
Thank you, Mr. Chairman. My only question on this is, you're applying it only to that paragraph. Should it not be part of the, I'm not an attorney, so I'm just asking a question. Should it not be part of a definition section somewhere?
Representative Probst.
Thank you. I think that we put it here. There wasn't really, I didn't really see much in the way of a definitions section in this bill. So I think we put this here just to qualify this one part.
Charles, would this affect other statutes that have the same type of wording, or would it only affect this statute?
Chairman, I believe the limitation for purposes of this paragraph would limit it to use here in this Self-Storage Act for purposes of defining commercially reasonable, in fact, just in that paragraph.
Any other discussion on the amendment? Representative Miller?
Mr. Chairman, you asked a good question, and I wanted to embellish the answer a little bit more. Commercially reasonable is defined several times within the Kansas statutes, and it's defined differently depending on the statute.
Well, thanks for that clarification.
And qualifier, I am a lawyer, but not a good one.
I've heard. Representative Williams.
Sorry to ask again for clarification, but for those of us that can't read that, can you read it one more time?
Certainly, Representative. The language is, for purposes of this paragraph, commercially reasonable manner means a manner of advertising that is, in the jurisdiction where the sale is to be held, widely circulated, published, or available online on a consistent and regular basis, and is a known source of widely shared community information.
So Revisor, does that mean that chain emails to a group of people that subscribe to this type of common action, as the chairman mentioned, would not qualify under this definition? So if you were part of a group, a listserv group, if you will, so not technically published repetitively or in a traditional manner, but it's a group of individuals that participate in this type of activity. Maybe they're part of some type of organization, or they would not qualify under this definition, correct?
Well, Representative, I'm not familiar with the type of listserv that you're describing. However, if it was widely circulated in the jurisdiction, if it was published or available online on a consistent and regular basis, and I guess particularly with a listserv, I suppose, if it was actually a known source of widely shared community information, then potentially it could qualify, but it would have to meet all three of those requirements.
Okay, and that may be my concern, is sometimes in statute, we are ambiguous for a reason. I know in the Department of Education, we have dozens of statutes that are ambiguous like that. For example, a needs assessment. It's just one that pops into my head. We don't define that. We let the schools define that. Or we let the state board define continuous learning. So I'm just concerned that that's going to limit how, if you subscribe to an organization or an entity, that you could be disqualified because you may not meet all three of those. And what it could do is that you go back to the traditional rather than modernizing and allowing us to see where there's access to this and how, maybe ways that we are not aware of.
Representative Sutton.
Thank you, Mr. Chair. In reading over the amendment, it's a little small on my phone, but nonetheless, if the storage unit placed a notice on their website, it doesn't look to me like that would, even though people who are looking for an auction of this type would be looking on that website, it doesn't look to me as if that would meet the requirements brought forth by the amendment. Published online, check. On a consistent and regular basis, no, probably not. We've looked at maybe, unless we call, 3 or 4 times a year regular or consistent. And then also, the one that really sticks in my mind is the known source of widely shared community information. They really wouldn't be qualified under that category because it's not. Am I understanding this correctly, Revisor?
Representative, yes, all three requirements would need to apply if that is your question. So, and yes, that it be a known source of widely shared community information would be a requirement.
Thank you for that. Yeah, to me, this looks like we're just trying to go back to publishing it in a paper of record. I think this is the same amendment we just voted on, as near as I can tell. Thank you, Mr. Chair.
Representative Carpenter.
Thank you, Mr. Chair. And following along the lines of Representative Sutton, could you define a known source of widely shared community information?
Charles, I think that question was for you.
I'm sorry, Chairman, I didn't understand that was for me. So that is just would be defined, the plain meaning of the terms. There's no specific definition for that phrase.
No example examples that you can think of?
I don't do a lot of shopping online, but obviously a newspaper of wide circulation would probably fit that definition. Possibly a well-known source of sales information. One of the regular online sources. I'm drawing a blank on a name for some of those, but Craigslist or something like that. I mean, it's possible that would fit that definition if it was also, widely circulated and online on a consistent, regular basis. And in that jurisdiction, it was a known source of widely shared community information. So it would also, in a sense, depend on the type of community. What in that jurisdiction is actually a known source of widely shared community information. So it would be somewhat dependent on the location.
Point taken.
Representative Probst.
Thank you, Mr. Chair. I might follow up on that. In my community, if 4 cop cars go flying down your street past somebody's house, you'll go to Facebook gossip page to find out what's going on. I could see under this definition a number of places, a community calendar page. Our city has a page with a lot of activities and events going on. I could see that as an acceptable place. Paid Facebook advertising or Google advertising might be an option. And again, I will remind the committee that I would welcome input to improve this. I do think that we have a legal gap here where we haven't adequately defined this term, and that's the motivation behind my effort here.
Any further discussion? Representative Johnson.
Thank you, Mr. Chair. And just trying to weigh in on the different things that are here. In my area, I'd have a couple of different settings where in Ellsworth there is a small paper that meets that need fairly well, and I could see that continuing to be the source of information that folks might expect to go to, even similar in Lindsborg. In Salina, the paper has a much broader coverage and is a little more expensive, so for the same sale it may be harder and there might be a more targeted solution that fits. So while I don't know the best definition of the commercially reasonable manner, it may make some sense just to make sure that we know that whatever it is agreed to by everybody for what it looks like. I think in most of the cases, our folks doing the selling are going to make every good faith effort to get good qualified bidders there. But it may help as we make a change to try and get our arms around that. So I appreciate at least an option being brought. Thank you.
Representative Curtis online.
Thank you, Mr. Chair. And actually, that was the previous representative kind of went down that line of questioning. I was just wondering, too, if there was any outreach to see if this is a definition from the people who brought the bill to us, if that was something that that they had weighed in on as well. So that was my question as well. Thank you.
Representative Probst, did you get any input from anyone else?
No, I did this between breakfast and lunch today.
Good work. Representative Ralph.
Thank you, Mr. Chair. I don't do much work in the particular area of uniform commercial code or such, which is, as one of the representatives previously indicated, that you see commercially reasonable process show up in the uniform commercial code in several spots in the statutes. You might find some instances where a sale is supposed to be done in a commercially reasonable manner, and then the statute actually says that sale will be considered commercially reasonable if, and it'll list out A, B, and C, things that need to be done. You'll find other statutes where you just simply say something will be done in a commercially reasonable manner without a definition to it. So it's hit and miss in that regard. In this particular item, I have an appreciation for what's attempting to be done, but it strikes me that maybe this conversation specifically in regard to notice may be best served by simply using the term commercially reasonable, because in that fashion, it would allow any particular jurisdiction to adapt, as the previous representative indicated, as to what's commercially reasonable in Stafford County or in Rush County or in Sedgwick County may be incredibly different in terms of whether it needs to be online or not. So I'm thinking that maybe specifically in reference to notice, not talking about the sale, the terms of the sale or anything else, but specifically with notice, this would allow a court to determine or have some discretion to determine in this particular county or in this particular locale, yeah, you ought to be online. Or in this particular locale, simply a listserv is not sufficient because that didn't get out to the public. So I think in this instance, it strikes me that maybe leaving this undefined would actually provide the courts the opportunity to do equity for someone who feels they've been aggrieved by being able to say, yeah, that particular process was good in this circumstance, whereas in another location it wouldn't be. So for what it's worth, Mr. Chair, thank you.
Thanks for that. Any further? Representative Probst?
Thank you, Mr. Chair. On that, I have a question to the representative from Dodge City. If by not defining it, we create the flexibility for the courts to use local determination on the availability of what would be commercially reasonable, does that potentially create any legal wrinkles somewhere else? If the court has found that this is acceptable in Stafford County, somebody in Johnson County tries to make that claim based on case law in Stafford County, do you see any potential wrinkles there?
Representative Ralph.
Thank you, Mr. Chair. Those crafty attorneys will always try something out there. But I would say the direct answer to your question, no, the courts, and I think probably several other representatives here would say that I don't think the district judges have any difficulty in crafting their own resolutions or determinations within their own courts or within their own counties. So someone might certainly make that argument, but I would probably lean the other direction to say that a district court would be much more likely to have their own internal process. And then I think what you'd find is within those particular locales, for example, a local bar or the local owners, storage unit owners, such, they would know here, this is what we have to do.
Any further discussion? Seeing none. Representative, you may close on your amendment.
I appreciate the committee's indulgence, and I'm closed on my amendment.
Committee, you've heard the motion, seconded by Representative Miller. All in favor, say aye.
Aye.
All against, say no. Noes appear to have it. The noes do have it. The motion fails. Representative Probst, do you have any other amendments? Okay. Is there any further discussion on the bill? We're back on the bill. Seeing none, Representative Long, you may close.
Thank you, Mr. Chairman. I close.
Committee, you've heard the motion. All in favor of passage of HB 2112? That's it, right? Please say aye. All against, say no. Motion passes. We'll move on to discussion and action on HB 2097, and we'll get a briefing from the reviser. Charles.
Thank you, Chairman. This bill simply decouples the requirement currently in the Department of Commerce's Economic Development Program, the High Performance Incentive Fund, from the requirement that there be participation in the workforce training programs. So under current law, that is a requirement in that high performance incentive program. And this bill removes that requirement for participation in the workforce training programs. That's what the bill does.
Any questions for the revisor? Online. Charles, I sent you an email earlier on qualified business, and I'm just now seeing that you responded to that, but it was rather lengthy. Could you explain what a qualified business is? Is it limited only to corporations, or is it open to, partnerships and LLCs and things like that?
So for purposes of the high performance incentive program, I believe that the taxpayer that is eligible for a credit under that program would be a C corporation. And that's because, just because of the language of the program, and also because only C corporations are actually are taxed with Kansas income tax. Entities such as partnerships or LLCs, of course, are pass-through entities, and the individuals that are a part of that business are responsible for the tax. So this would be subject, the Department of Commerce are the experts on this program, but just, from reviewing the statutes, that would be my understanding.
Okay, so there would be no way for a partnership or an LLC to receive tax credits because they don't pay taxes. Would those be able to be transferred down to the individual, like the pass-through?
I don't believe there's any provision in the high performance incentive program for passing tax credits down to individuals.
Any other questions? Seeing none, Representative Long.
Thank you, Mr. Chairman. I move the committee recommend HB 2097 favorable for passage.
Seconded by Representative Clayton. Discussion? No one wants to weigh in on this? So I would like to find a way to expand the HPIP part to LLCs and partnerships. However, I think that's going to need a little bit more work, and we'll have to discuss that at a later day, because I don't want to mess it up. Any other discussions? Seeing none, Representative, you may close.
Thank you. I close.
Committee, you've heard the motion to pass out favorably HB 2097. All in favor, say aye.
Aye.
All against, say no. Motion passes. That's all I have for today, committee. I made an announcement today from the well, and I made two errors. The first one, I didn't have the bill number with me, and the second one, I said we were going to hear it tomorrow. We are going to start the process of hearing the unemployment bill on Thursday, and it is a large bill, and so we're taking Thursday to only go through the bill. You all have a copy of it. It's filed underneath the Commerce Committee online. If you would take a look at that, my guess is there'll be plenty of questions, and it will take the entire day to go through the bill. There'll be a couple of people here to help explain it, and then we will start setting up proponents and opponents the following week. Probably not Monday because of the Super Bowl. We'll probably reserve the excitement of the unemployment bill for Tuesday. So that's kind of an update there, and thanks a lot. Thanks for everything. We're adjourned.